Welcome into On the Mark. However, because of the comms and the P. Diddy trial that we are covering, we are going beyond the mark. I'm Anita Marks. You see me all over ESPN, and my partner in crime, no pun intended, Nevin Shapiro is joining me. Obviously, we're going to be covering the sex traffic trial of Sean Diddy Combs, which started on Monday. It is now Friday. So we're going to look back. We're going to recap the week that was and look forward to Monday and what is coming. We have a very special guest who's going to be joining us, Cathy Fleming, one of the best white-collar crime attorneys in New York City. She's tried more than 80 cases, majority in federal courts, licensed in New York since 1980, went to Columbia University. And let me tell you something, she is one of the best in the biz. And no one better right now to have on than talk about all the proceedings and everything that took place this past week with the P. Diddy trial. But without further ado, this is episode 2. And Nevin, some of the feedback we got from episode was, what exactly did Nevin do? What did he go to jail for? What did he plead guilty for? And so I guess I just assumed, right? Like, majority of people I know your story. So for the folks that are tuning in for the first time, who really have never known you, never met you, why don't you kind of explain your story, Nevin?
Will do. Thanks, Anita. Well, I was tied up for about 100 years, so now I'm back, so I can explain. Time just stood still for me. But anyway, so most people know me from my infamy from the University of Miami football scandal that took place in 2011. But what really got me tied up with the federal system was I surrendered April 2010 to federal authorities in Newark, New Jersey. Inevitably, I had to plead guilty to 4 counts of money laundering and 2 counts of securities fraud to the tune of $930 million. So not that I'm getting an award for this, but in the annals of time, at that time was the 4th largest financial crime in the history of the United States. My judge sentenced me. I pled for 10 years. I agreed to a plea for 10 years, and the judge gave me a 2-level plus upward departure to the tune of 20 years. So I was sentenced to 20 years in federal prison. Fortunately for me, unfortunately for society, COVID happened. And I was given, I wasn't given clemency, but I was let out on the CARES Act and sent to house arrest, where I was able to serve, it'll be 5 years in June, but I was recently, in December 2024, given clemency from President Joe Biden. And so now I'm out and I'm on supervised release in probation status. But I went away for money laundering, 4 counts, 2 counts of securities fraud, and I was given a 20-year prison sentence.
And the reason that you and I are doing this podcast and in this digital show is the fact that you kind of have been in the same building, maybe possibly been in the same cell as P. Diddy is experiencing right now, and kind of, even though you took the plea deal, as we know, P. Diddy did not take the plea deal, hence why the trial started on Monday. But you're very familiar with many of the steps and many of the situations that he's been encountering.
I bring an absolute unique perspective to anybody that's watching this. I challenge to say almost there's maybe nobody left in the United States that's been in that exact tier who's still alive to talk about it, or free anyway. It is hell on earth. Psychologically, I know exactly what this guy is going through right now. And he is talking to God often, like 24/7. And it's you want to be able to fight these people from your own home and show up to court in a new suit every day, as opposed to be told you got 5 outfits, period, and pick one. And he's going through it psychologically.
Well, we've got a very special guest who's joining us. Let's bring her in, and that is Cathy Fleming. I met her on a golf course, and unbeknownst to me, one of the best defense attorneys in the country, really, and your reputation is just unbelievable, and we're really blessed to have you on the podcast, Cathy. Thank you so much for joining us today.
It's my pleasure, and you're being too kind.
I'm just,
You know,
I'm, I'm
can we
stating the
mention that
facts.
can we mention that you were present for my hole in one?
I was I was president for your whole. Yes, I was, and that was really exciting. So Cathy and I have been friends for quite a while, and so therefore, you've tried more than 80 cases, and the majority in the federal courts, and you know a lot of these players as well. So I thought, who better than to have you on to talk about some of the topics that everybody wants to be more in the know about. And so let's start first and foremost with the final jury selection, which today was put on hold. So they went from 150 to 45, which really right now is 43 because two more were dismissed today. So they've got to go from 43 to 12 jurors and 6 alternates. However, the defense, PDD's defensive team, came out and expressed concern, quote unquote, that people on the panel might get feet before the start of the opening statements over the weekend. So they felt that they wanted to put that selection on hold until Monday. What are your thoughts with them suggesting that, and the judge said okay?
Well, I think it's probably a smart move because it gives them the weekend to think about the whole panel of their pool of 43 instead of picking the 18 people, the 6 alternates and the 12 who will vote as a jury. So it gives them more time to discuss it. Following up a little bit on what Nevin said, it's not only that the defendant's not home being able to prepare, he's incarcerated, and he's incarcerated in bad circumstances. He's in the SHU, the special housing unit, which makes it very difficult, not impossible, but very difficult for defense counsel to meet with him on a timely basis and go over these things. And I know that if I wanted to have a jury that of my peers that I thought was picking my future, I would want to have the opportunity to consult with my lawyers. So I suspect that part of the theory here is that they're going to spend the weekend discussing who are the best that they can get out of the pool if they get called appropriately, etc. And I also do think people are going to get nervous about being on a high profile trial. They're not sequestered, but they are nameless. The lawyers have their names, but they're nameless to the public so that people in the public, the media, and others don't hound them.
The defense team is allowed to strike 10 potential jurors, and the prosecutors are allowed to strike 6. Why is that? Why is it 10 and 6?
There's the federal rules of criminal procedure provide for that, and then you get 2 and 1 on the alternates. That's for your 6. That's for your main jury of 12. You get 10 and 6. If I'm with the high profile cases that I have tried, we have generally asked for more strikes. And remember, the strikes, there's 2 kinds of strikes. There's a strike for cause, meaning that somebody has said something in the questioning that leads one side or the other to believe that juror can't be fair. They say, my brother's a policeman and he has arrested 52 people in these kinds of cases, but I can be fair. Sometimes you can go in and argue to the judge, look, this person should be dismissed for cause. I shouldn't have to use one of my 10 peremptory charges to get rid of him. But if the judge says, no, I believe him, he says he can be fair, then if you want to strike him, you use a peremptory charge. And, picking a jury is a real art. I don't see in the press that they're using a jury consultant, but I would be surprised if they weren't on the defense side, because it's very helpful. They have a lot of experience and research on the kinds of jurors that you might want to pick for a trial. And so a lot of it is figuring out, okay, I really don't like juror, number 11 and 12, but I look at the pool behind me and they're worse than 11 and 12, so I may have to stick with 11 and 12.
Just out of curiosity, two-part question here. If you were Diddy's attorney, what type of juror would you be looking for? What would be like the top 3 things that you would be looking for in a juror? And also, how much are you consulting with P. Diddy in regard to picking that jury?
Well, first of all, I'm consulting with my client on every pick and every dismissal because at the end of the day, I get to go home. So I think it's an important thing to have the client deciding with your advice and with your thoughts on who actually gets picked. And there are times I've had knockdown dragouts where I have not agreed on my client and we really fight it out. But at the end of the day, it's the client's call. It's hard. There's some general wisdom. You've got a celebrity here and you have somebody who's going to have a lot of fans. I saw pictures of people outside the courthouse saying "Free Diddy," and so if I can find jurors who I believe, based on their expressed interests and their background, that they might be more sympathetic to this particular celebrity, then I'm going to be more inclined to choose him. It happens that I'm a grandmother, but the traditional wisdom would be you knock grandmothers off the jury. They're not going to take well to the kinds of allegations that are here. That may change now that grandmothers are all from the 60s and the 70s, but that would be traditional wisdom. Another kind of juror that I like young people on a jury, and in most cases, and I like people who are particularly interested and influenced with social media and the kinds of things that would be attractive to people about this defendant. I certainly would not want to pick any juror who had never heard of him, because that would be somebody who lives on another planet. Another thing I look for is I like picking people who have advanced degrees, like PhDs. And I may be in the minority on this, but it's been my experience that people who have done a lot of studying and gone to school for a long time are quite cerebral. And they don't just accept at face value everything that is fed to them. And sometimes I have described that sometimes the PhDs try to outthink everybody in the courtroom. But I like that because remember, again, the prosecution has to convince 12 people unanimously to say he's guilty. The defense only needs to convince one to say he's not guilty, and then you at least have a hung jury. And it's hard if you only have one who says not guilty. They kind of get beaten up by the other 11 and they fold a lot. But if you get two, so one of the other things that I look for is, are there people that I like who seem to be getting along and having a relationship on the jury? Although in general, I am looking for the loners who aren't going to want to get along. I don't need a group that's going to be all friendly and lovely. I had one jury in East St. Louis where on the 4th of July weekend, they all came in dressed the same. And we all said, oh my God, we're done. This jury's going to agree on a verdict, because not guilty is our best verdict, but hung jury is not a bad second.
So, Nevin, again, you took a plea deal, but, hypothetically speaking, what Cathy's talking about here in regard to this jury selection, agreeing to everything she's saying.
Let me tell you something. First of all, Cathy, where were you when I needed you? But now getting moving, this is such an art of what Cathy just described that you just watched, even though your viewers, Anita, and probably yourself as well, have never seen someone in this act. That was poetry in the legal realm. That's how deep this, like, it's so deep that the common person can't really grasp it. I can, because I've been sitting next to Cathy and she's going home and I'm going back to my cell. And it is the lowest feeling, and she is spot on. This is an art, what she does and what her colleagues do. And it every situation matters. It's split-second decisions, and you think you're winning, then you're not. You think you're winning, and then you're not. It is an ebb and flow, give, take. Who's got the momentum? Who's taking it back? And boy, what she just broke down was just, to me, was just like reading a book that I've read 1,000 times.
One of the problems sounds like a basketball game.
Yeah.
One of the problems the prosecutors face, can I jump in for a minute, is that this TV show Bull suggests that there are jury consultants who are out wiretapping and invading people's privacy to learn everything, checking their brain scans. None of that's true. The people who are very good at this, and there are some consultants who are fantastic at it. What they do is they gather data by they will go find a jury that mirrors what the kind of jury pool we're facing. and they go, and sometimes we do mock trials. They're very useful with a pool of people that look like what we think we're going to get in a jury in our cases. And we're able to talk to them after they've heard a presentation of both sides to find out what troubles them, what doesn't trouble them. It's really, when somebody has the resources that Mr. Combs has, it's certainly a useful exercise to do it. I'd be shocked if his legal team, which is a superb legal team, did not do it.
Um, Cathy, again, Nevin did agree to a plea deal. Obviously, different crime, different charges, what have you. P. Diddy's 55 years old. Apparently, reports are out there alleged that they did offer him a plea deal that he turned down. Um, agree or disagree with that? If what are your thoughts on him turning down the plea deal? Because everything that I'm hearing is, if he is found guilty, the judge does not take that lightly, and the punishment will be greater.
Well, it's not that the judge doesn't take it lightly. You get sentenced according to something called federal sentencing guidelines. And it's literally a mathematical exercise in the first instance where the judge has to get a presumptive sentence and then you work off it. And among the other things is you get point scores for how much is involved in the crime, what kind of crime it is. And then if you plead guilty, you get either 2 or 3 points off. So your presumptive schedule starts off lower. It doesn't always work that you get a higher sentence if you go to trial. Sometimes it's a long sentencing hearing, and the prosecutors have offered a deal that's so untenable that you might as well go to trial and let the judge really see the good sides of you and see it's not the case that the prosecutors are painting. But, the idea of taking a plea, it's a very personal decision. I had one client who was offered a deal with probation. I urged him to take it, saying, you don't want to risk federal time. And he said, I would rather die in jail than tell my children I did something I didn't do. I've had other people who've said to me, I'm not taking a plea. If you even discuss it with me, I'm going to fire you. I am going to trial. They are wrong, and I am going to do this. And I get hired to try cases. I get brought in frequently to try cases that people can't resolve. It's a very individual decision. With the charges he has, I don't know what the terms of the offered plea is, but I'm sure it was a substantial sentence, incarceration, not to mention forfeitures and restitution and fines he would have had to pay. But if he's 55 and the plea deal was a 15-year sentence, you do 85% of it, you get a little bit more off, but that's still a long sentence too. And if you've got a credible defense and you think you can pull it off, and you have the celebrity status, which I think does help people with juries. People tend to be better to celebrities than non-celebrities. I think it's not a decision that somebody can fault him for. The biggest problem is, at the end of the day, if you're found guilty, do you regret that you didn't take the plea? But the other side of that coin is, if you plead guilty, do you regret that you didn't have your day in court?
Cathy, let's talk about the teams here, right? Because you seem to be pretty familiar with one or two of the attorneys for P. Diddy, correct?
Yes. I have had cases. I've been co-counsel with Mark Agnifilo, and I've had cases with him over the years. I think he's a terrific lawyer. He's a very fine lawyer, and I think that he will do a good job being lead counsel here. I also know Alexandra Shapiro quite well. She's who I send all my appellate work to. She's one of the best lawyers I've ever seen. She's a terrific, smart mind. She clerked for Ruth Bader Ginsburg. She's really smart woman. So I think that they've got a very good team on the defense side. I don't know the prosecutors. Prosecutors tend to have the huge advantage of having the federal government at their beck and call. They can marshal evidence. They have very talented younger people in the office who are wizards with the electronics, show and tell at trial. And they have the prosecutors. Most assistant U.S. attorneys are very smart, ambitious people who know what they're doing.
So the 8 assistant U.S. attorneys, 7 of them are women. what are your thoughts about constructing a team that's 93, what is it, whatever, predominantly women?
Well, my initial thought is thank goodness we're finally getting teams of primarily women. It's a rare thing. It was recently that I had a judge, a defendant, a defense lawyer, and a prosecutor, and all of us were women, and all of us commented on it in the courtroom. I think that it is important to look at the composition of your team. I am offended at window dressing, where people for years said, "Oh, I've got a woman I have to have a witness with, so I'll throw a woman on who's not really important on the team, but she can be window dressing," or "I have a person of color, so let me get a person of color." I think you pick talented people who are good at it. Having said that, I do think that particularly when you have victims of sex crimes, which is what the prosecution is alleging here, women tend to have softer approaches than men do when they're cross-examining victims. And I think that's probably helpful. I am sure there were 50 very fine assistant U.S. attorneys who could have been picked. This is probably a team that works on these cases. I've read that. I've read that they're in this unit that does a lot of this kind of work. And I will tell you, I do think, I've thought for years, that it's a tremendous advantage, particularly in a criminal trial, to be a woman in the courtroom.
Nevin, kind of, share with us your experience in kind of analyzing and seeing how this is all playing out. It's great we've got Cathy on, an attorney, and how, the fact that you're not going home, right? You're not leaving and exiting the courtroom with your attorney and then coming back the next day. How does that all play a role?
So let me tell you. So when I was going through my pre-sentencing phase of this, I had not been in the shoe as of yet, right? Because my case became more high profile later on with my non-criminal situation with the University of Miami. But what Cathy was saying earlier, as far as like having to go see your client in the shoe, there's such a process of an hour. You have to wait for your client, then they got to bring you out, and if you're in the shoe, they don't have keys to get into the cage, meaning the officers there. They got to be buzzed in because you're under solitary confinement. You're under like special housing unit. It's terrible. So what goes on behind the scenes is never seen by the public, but it is a nightmare. What should take 30 seconds, let's go get a drink after we just left court. Let's say Cathy's my legal counsel. All right, let's go at this restaurant. We'll sit down. Let's have a drink and really figure it out. That's not what's going on here. These are all day knockdown, drag out affairs, and you're limited on time because they shut the prison down at a certain time, 10 o'clock, midnight, 11. It all depends. It's different for certain places because you got to go to count time, and it's a nightmare. It's a nightmare. And when I told you this, Anita, in our initial segment, that the underlying theme of this situation was him being denied bail, crucial mistake, not a mistake, but not to his benefit, to not be awarded bail. Crushing blow. Mentally.
And just to go back, right? There were a few reasons why. One was concerned about him being a flight risk, but number two was him reaching out and tampering and trying to persuade the witnesses to not testify.
Witness tampering.
Yep.
He made his bed in this situation. I have to say, with no dog in this fight, he made his bed to make it easier for the prosecution to have bail denied by reaching out. And when you start trying to have other people use the phone, see, if you've never been in, you don't know what it is. Just call this person for me, do this, and that. They got eyes on everybody, and you don't even know who's next to you inside that's reporting back to the prosecution or the police officers. That's why when unfortunately, if you had to be there like I did, you're warned by your attorney, don't talk to anyone. Don't say anything. You don't know who's who. You may be talking to an informant or a cop. You don't even know. And there's so many games behind the game that everyone's watching that it's terrible.
A lot of truth to that, Cathy?
It's essentially Dead on, spot on. It's tough for the lawyers too, because the client is not allowed to carry books and pencils, and there's a whole procedure even for them to take notes back to the jail. We are barred when we go into the federal jails. We have to get special permission if we're going to be able to bring in any electronics, and it is denied most of the time, candidly. So you're going back over, and you can use a computer that they have given to the defendant in jail that has the discovery loaded, but now my notes are not on it. It's only on that computer. So you're limited in what your resources are. You've done a full day at trial, you're exhausted, and you go over and you wait, and you have to go through these procedures to get in, and you're limited in the amount of time you can see. If I'm thinking, if it's 5 a.m. and I have a crucial question as I'm preparing cross, I can call my client, who's generally awake, and say, what's the answer to this? I want to think about this. You can't do that when they're in jail. It's just impossible.
Cathy, have you ever had a client that you were working with that you were worried would dabble in witness tampering?
No, I've had clients that the prosecutors accused or suggested or intimidated were attempting to intimidate witnesses, but they've all been cleared. It's one of the things that you tell a client right up front. Don't take a case that we can win and turn it into something that the government can win by contacting the witnesses. If we're going to speak to witnesses, there's an appropriate and ethical way to do it, and it's through counsel, and we'll take care of it. And I do not believe that anyone should witness tamper. I do think the prosecutors look a little, they take it not too seriously, because witness tampering is serious, but when some of the contacts that are incidental or accidental, that they blow up into something more than that, or a problem. But
All right. Well, with that being said, let's get right into it, because this was another big storyline that came out this week. And so, at first, we were told that there were going to be 4 victims, 4 witnesses. Victim number 1 is expected to be the ex-girlfriend, Cassie Ventura. Right now, apparently, the Diddy's team want to question her regarding the propensity, quote unquote, for violence and instances where she has been violent. They want to illustrate her nature of getting into physical altercations with other people, and she does not shy away from confrontation. So the judge is declining to issue a final decision on that matter until Monday. But again, the storyline here is, P. Diddy wants it to look like, hey, listen, I was a victim of abuse as well. Wise on Diddy's team to walk down that road, Cathy?
well, if you have somebody who's going to come in and testify that she was tuned up all the time by him, is it better that they stay silent about the fact that she was also violent? I think that's a tough call for anybody to second guess without having spoken to the client and seeing the witness statements. But I'm not going to second guess that. I think I would rather have it come out that it was a two-way street if there was violence. As I understand it, what they were saying is that it's domestic violence, it's not trafficking.
Victim number 2, anonymous testimony about financial losses, dependency, and coercion, all which made her vulnerable to P. Diddy. Now, here's victim 3 is interesting as well. And this is the one that I really want to speak to you the most about. Apparently, the prosecution has lost contact with victim number 3. And apparently, as well, she's always made it known that she did not want to testify. And the prosecution has said, listen, we don't know whether she intends to appear. We're trying very hard to find out, because we're having trouble communicating with her. Apparently, they're having trouble communicating with her. And so what do you do if you're the prosecution and you've got a witness / victim number 3 who doesn't want to testify to begin with, Cathy?
Well, I generally, even as a federal prosecutor, I really was not happy when witnesses were unwilling to testify, although very few people really want to testify. But if you have a witness that you think is going to be reluctant to testify or is going to change his or her testimony, you put them in a grand jury so that you can preserve the testimony to help you. So if they get on the stand and say something different, you can cross-examine them. Of course, the grand jury is a tool only available to the federal prosecutors. It is not available to the defense team. If you're also concerned, you make sure that the witness has been handed a subpoena. A subpoena is a court order that says you must appear and testify. And federally, there's jurisdiction in all the states to have somebody receive a subpoena to testify. So that it is a bit of a hammer here. If they have in fact subpoenaed her to come and she does not appear for the trial, she could be found in contempt and have her own legal problems.
Mm-hmm.
It's really one of those things that if the hardest thing about being a lawyer when you're on trial is marshaling your witnesses, getting them there, getting them on time, arguing with them that their dental appointment's not as important as your court date. It's a tough problem, but if they've done their job properly, they have grand jury testimony to cross-examine. They can't just put the grand jury in. The defense was not there. They didn't have an opportunity to confront and cross-examine. But they do have it that if she's reluctant and changes her testimony on the stand, they could cross-examine her if they put her in a grand jury.
Interesting. Victim number 4 is a former Diddy, allegedly coerced into sexual acts. And then earlier today, Nevin, you told me now they're going to be adding a victim number 5, apparently, right?
That's what I read based on tracking this case. For my own knowledge and interest, aside from our situation here. And they said there was mention of a victim 5, a witness number 5. Yeah.
So how to add a victim this late, Cathy, red flag for the prosecution, or is that normal?
It's not that it's normal, but the prosecution does add witnesses at the very end. And things do happen, and it happens on both sides. There may be witnesses who come forward on the defense. I don't think it's a red flag.
This is a poker game, Anita. This is really a full-fledged poker game. It goes on both sides. Cathy will tell you.
Yeah, and I have no interest or desire to ante up or be a part of this game. Last question for you before we let you go, Cathy, and that is, so Monday they're expected to make the jury selection. Apparently, court is going to begin an hour early to make sure that they can get that in, as well as opening statements. What can you share with us in regard to opening statements? Give us a little quick peek behind the curtain.
So an opening statement is supposed to be simply a statement of what you anticipate the evidence will prove. And that's contrasted with your closing argument, where you're supposed to be allowed to argue why the evidence favors your side and your arguments. Any lawyer worth his or her salt knows to use the opening statement to argue their case. They do it cleverly by saying, here's what I anticipate the evidence will show, and then weaving some arguments into it. The jury research shows that jurors make up their minds after the opening statements in 65% of the cases. Which is why the defense always has the opportunity to wait and open at the beginning of the defense case instead of on the first day of trial. And it is very rare that you see that happen. That's only when you really don't know what's going to happen during the trial. So I think that what we're going to see, the prosecutors will get up and they will do a very clinical statement of, here's what the evidence is, here's what the witnesses will tell you, here's what the documents will show. And at the end, we're going to come back and ask that you find guilty on all counts. The defense will either, if they have strong points that they know they're going to live with in their defense, they will also set that forward. But they'll also talk about reasonable doubt. They'll talk about how this is something that reasonable doubt is something that it has to be something that you would not fail to act on your own. If you have any reasonable doubt because you'd hesitate, then you shouldn't do it. And they will cleverly get some argument in as well as do an opening statement.
Nevin, any final questions for Cathy before we let her go?
I think she really broke it down to an exact science of what this is. I think this is going to be, like I've said, I think Puffy's team he's got an army of a dream team, and I know from the other side they're bringing in their form of a dream team. This is going to be a shootout between two powerful legal squads, and I just say it's a 50-50 situation. I stand on that. I think it's in God's hands. I really do.
There's one other factor that's really at play here, Anita, and that is the presence of all this press. I've tried cases that were the front page New York Times cases, and everybody involved in the case acts differently. The judge, the prosecutors, the defense attorneys, you're much more conscious of all these people watching and reporting, and you have to be far more careful about everything you do. You really can't let your guard down for 2 minutes because it gets reported. So the fact that there is so much press in this, it just means that everybody in the courtroom will act a little differently than they would without all the press coverage.
One,
Interesting. But
one thing
I
I would
just want to
say,
I want to
Anita,
piggyback on what Nevin just said. So in our discussion that we've had there in the last 30 minutes, it just sounds like, all right, the prosecution has all the federal government behind them and able to really do a lot more and be a lot more aggressive, right?
Well,
Where and
well,
we're in
Diddy's one in a gazillion because he's got the resources to counter it. And I
and that's
know
where
I know
that's
I've told you this privately. If you have the stomach for a trial, if you have some facts that help you, and if you've got the considerable resources it takes to hire the best lawyers, the best experts, the best forensic people, you can even up the odds considerably. It gives you a much fairer shooting match when you have people that have resources on the defense side.
that's where I was going to go with this. So, in
Right.
essence, Cathy, I mean, are we looking? Are we in the midst of like the Super Bowl of all trials?
I won't know until that's over. I watch a lot of good high profile and not high profile cases. I like to watch trials. And I think watching good lawyers on both sides with a good judge presiding, it's fun to watch it. I'm not sure if it's the Super Bowl. It's at least the Housewives of New Jersey with the amount of press coverage that's going on here. Uh, as I said, it's really scary when you have the kind of press that's there because the stakes are so high, and you have people criticizing what you're doing as you're trying your case, and you know what you're doing. And the only other thing I'll say about the press is now that people tweet constantly during the trials, they get a much more accurate description of what's going on in the trials. Federal court does not allow cameras, so they rely on print journalism and they rely on courtroom sketches. But it's hard. There are many times I've tried a case and I go home at the end of the day and I read the paper in the morning and I say, were they in the same courtroom I was in? Because that's not what happened. That's not what the ruling was. That's not what the witness said. Or, boy, why didn't they stay for the cross examination when the real truth came out? So it makes for a much more interesting. It's certainly a high profile case. I don't think it's quite the level of OJ, but it's certainly a high profile case that a lot of people are watching.
Cathy, we so appreciate your time. Thank you so much. Would
My
love to have
pleasure.
you on again. We're going to be covering this trial. Apparently, it's going to go on for the next few weeks, and so as your time permits, we would love to have you back, my friend.
It's my pleasure. And we got to play golf soon, Anita.
Absolutely. I've got to put down my pickleball paddle
Yeah,
and pick up and get back to my golf clubs. But absolutely, we'll do that soon.
great.
Thank you.
all
My
right.
pleasure.
All right, Nev, Cathy Fleming, unbelievable, such great insight, right?
Wow.
Um, Here's my thing for you, and that
Yeah.
is, so it's the week that was. Now Diddy's going to be stuck in this confinement Saturday, Sunday. I would imagine Monday can't get here fast enough, or is it a mixed bag? Like pick your poison. Like he's
Yeah.
stuck just marinating in everything that happened this week, but yet really Monday is when the shit gets real, right?
Phew. Anita, you could just quote that. This shit is getting real Monday. Okay. This dude's staring at it. He's going to work with his attorneys over the weekend. That's going to be like his only semblance of oxygen. And then he's going to lose all his oxygen as soon as he has to go back to his cell. And when he walks out there Monday, it's like taking your last walk on a plank. It starts, and man, he wants it over fast, but he doesn't want it over fast. He wants it over fast because he wants his nightmare to end, but he doesn't want it over fast because he wants to make sure he gets in every punch he can get. And this is the ultimate, Anita. Like, this is the ultimate Russian roulette. This is it. I don't know how to stress it enough. What this guy is under right now is just, you'd rather be dead. The anxiety is just stiffening, deafening.
One thing, and we'll end on this, and that is that what Cathy said really stands out to me, and this is what's coming Monday, is, of course, deciding who the 12 jurors and 6 alternates are, but also all opening statements. Said 65% of the time, jurors decide on guilty or not guilty based on opening statements. That to me, that's a really big percentage without seeing or hearing all of the evidence.
So, Anita, you cover sports for a living on the regular, right? So and specifically the New York Giants. So like, you remember the Bill Parcells, the Belichick coming out of that tree. You could put your money on those type of guys in a Super Bowl. You know what you're getting. That's the lady you just had on speaking. She knows what she's saying. These are based on real numbers. That opening statement is big. Like, it's big. And it sets the tone. And I'm sure Diddy's people are going to come out banging. Like, I know they're gonna. They better, for 10 million, right? You get what you pay for. I know
10 million. They're saying this could be
all
anywhere between
99% of the world can't afford a defense like what this guy has.
They're saying minimum 10, Neb, minimum 10, possibly up to 90, depending on how long this case goes.
He's worth $1 billion. It wouldn't matter if it was 990. He's spending it, and you would too if you were in the same situation. I'm telling you, this guy is looking into the abyss. Maybe a month, 2 months from now, when it's over, he looks back and says, God, it was all a dream. That was my, Biggie reference.
Yeah, I've got the song now playing in my head. Nevin, great job. Cathy Fleming, phenomenal.
Awesome.
Folks, we're going to be covering this trial. We're going to post 2 episodes a week. So look for the next one to come out either Tuesday or Wednesday next week. And then we'll post one on Friday just to recap the week that was. If there's any breaking news, we will get to it and get a podcast out to you as quickly as possible. Again, I'm Anita Marks, on the mark. This is special. This is beyond the mark, out of my wheelhouse in regard to sports, talking all things P. Diddy with Nevin Shapiro. Please subscribe, watch, comment as well. We will reply to your comments and stick with us throughout the trial. We will bring you some of the best information, some obviously personal knowledge and feelings from Nevin, as well as some of the best attorneys and FBI agents in the country to break it down for us. Have a great weekend.